In its recent decision, the Kentucky Supreme Court on April 6, 2026, in the matter of Goodman versus Nemes et al., they have created a constitutional crisis pursuant to the Kentucky Constitution, Section 66 and 109. There is virtually no precedent in this country in the way this court has attempted to immunize itself from any accountability. Hopefully, there are legislators that will protect their prerogatives and power so they don't become the lapdogs of what looks to be an authoritarian and tyrannical court intent on seizing permanent power from other branches of government. Well, welcome back to Jack's Corner, where truth and reality has a seat at the table. Now, this is a special edition, and it's really more of a legal argument with regards to what's gone on in Kentucky. But, it has a lot of application across this country because so many courts across the country, and particularly in blue states where the judiciary is really out of control, and people need to be apprised of this and to know what's going on. But it's also important for the citizens of the state of Kentucky and how it impacts them. And basically, I'm entitling this, the Kentucky Supreme Court has declared itself unaccountable. Now, the Kentucky Supreme Court is, as I say, guilty of ultra vires. Now, that term means acting beyond one's legal power or authority. And in its recent decision, the Kentucky Supreme Court on April 6, 2026, in the matter of Goodman versus Nemes et al., they have created a constitutional crisis pursuant to the Kentucky Constitution, Section 66 and 109. We'll get into that in a minute. But the decision is a shameless and brazen attempt to strip the legislature of its impeachment powers, making the Supreme Court the ultimate ruler in Kentucky, as it can declare anything constitutional in nature and thus have the right to uphold or strike it down. This naked attempt to seize power from the people's house must not stand and will require the legislature to take a stand. This is a political theater hiding behind contortions of flawed logic. So why did the Supreme Court violate its own rules when it had a personal interest to rule as they did? Well, it's simple. They were protecting their own careers, and I'll explain that shortly. In its decision, the Supreme Court said that the impeachment petition was invalid on its face. Well, they have no power under the Constitution to make that conclusion because that's what the whole impeachment process is about. The House of Representatives first takes a look at the matter in its impeachment committee, and then it goes to a vote whereafter, if it is upheld, it goes to a trial before the Senate. It is the legislature that makes the determination as to whether or not the petition is valid or invalid. What a horrible and embarrassing statement for the court to make at page 5 of their decision. You see, folks, this is what I have been saying, that we have to have massive judicial reform in this country because incompetent people are finding their way into judicial positions and assuming powers that were not given them. The Kentucky Supreme Court declared that it is going to judge itself by itself, that none of its members or members of the judiciary can be removed from office by impeachment unless they've been accused and convicted of a crime, basically tantamount to murder or explicitly categorized as a misdemeanor. In fact, on page 34 of its decision, Judge Thompson had the audacity to threaten members of the legislature with bar complaints and crimes if they exercised their constitutional rights as representatives of the people and by not obeying the court ruling. This is seizure of legislative power. I believe this is, in and of itself, for a judge to accuse or threaten criminal prosecution because legislative members exercise their constitutional rights and duties as a separate branch of government is grounds for impeachment. Thankfully, the president of the Kentucky Senate has issued a press release within the last 24 hours advising that the Kentucky Senate will proceed with the trial that it is empowered to conduct by the Constitution. Now, this is typical of the political makeup of the state Supreme Court. And I'll just remind everyone that the members of the Supreme Court in Kentucky are elected and are more politician than they are judicial geniuses. They are anything but. However, the way that they are threatening the legislature in the way that they did in the case at hand arises to a federal review, and it wouldn't be the first time that the Kentucky Supreme Court and its decisions ended up in the federal courts. The issue at hand was the impeachment of a judge in Lexington, Kentucky, who refused to implement the laws, reversed on appeals numerous times, and was blatantly guilty of misconduct and malfeasance in office, whereupon the Kentucky House of Representatives found it to be so, and has referred it to the Kentucky Senate for trial. She was impeached by the Kentucky House. And an attorney in the area, that is in the Lexington area of Kentucky where the judge resides, brought the articles of impeachment before the House committee, which he had a right to do. And the House impeached the judge on solid grounds. Another striking and fallacious finding by the Supreme Court comes at page 6 of its ruling, wherein they state the facially invalid petition for impeachment did not allege that Judge Goodman committed any impeachable offenses. The allegations of misconduct should have instead been addressed solely by the Judicial Conduct Commission. Folks, there is no requirement in the Constitution that the unified courts that resulted from a constitutional amendment that the legislature was barred from exercising its inviolate powers of impeachment. The legislature has a two-step process in impeachment matters, starting with the House that examines the petition and the public official that is brought up on impeachment charges, who also has an opportunity to address those charges. Then the second step of the process is the Senate conducts a trial as to whether or not removal is in order. What the Kentucky Supreme Court has done here is to usurp the powers of the people's branch of government. Moreover, they have a blatant conflict of interest, which in and of itself arises to malfeasance. Let me give an example. If the president of the Senate in Kentucky was impeached, could he preside over his own trial? Clearly not. That would be a blatant conflict of interest requiring him to recuse himself and have someone else step into that position to conduct the trial. This is exactly what the Supreme Court has done because this is a conflict of interest and a conflict between legislative and judiciary. And let me remind everyone that the Supreme Court can only opine, not enjoin. The Kentucky Supreme Court has miscalculated and has engaged in conduct that could result in their own impeachment. Furthermore, it is the legislature that, in impeachment proceedings, determines what constitutes a misdemeanor and conduct requiring removal. Moreover, the Supreme Court is in violation of the separation of powers. And in this naked power grab by the judiciary from the legislature could bring impeachment proceedings against the justices, rendering this opinion. In fact, when you read the opinion of the court, it constantly tries to justify and insulate itself by acknowledging that even under the Kentucky Revised Constitution, the powers of the legislature to impeach are inviolate. There is no qualification on those powers. The one part of our tripartite government in Kentucky where the people have the greatest influence and power is the legislature. And this ruling is a direct threat to the citizens of Kentucky because anyone with $100 and an attorney can bring a suit, declare any grievance to be constitutional in nature, and then the Supreme Court would step in and determine who wins or loses. This is tyrannical and without the accountability of possible removal. The next most egregious part of the court's opinion at page 12, numeration 3, states that the impeachment hearing did not afford Judge Goodman due process. This is flawed on its face. The petition was issued to the House of Representatives and was addressed by committee and voted on by the entire House. The judge, subject of these impeachment proceedings by virtue of the process and the representation she had before the House, is due process. It's incredible that the Kentucky Supreme Court does not know the definition of due process. Moreover, the judge being impeached will have her day in court and be represented again before the state Senate. Again, this is due process, and for the court to make the outlandish claim that it denied Goodman due process is absurd. Folks, the Kentucky Supreme Court in this decision has an irreconcilable conflict of interest. And when you're sitting in a position as they are, and by the way, this would apply to any publicly elected official, if you have such irreconcilable conflicts of interest and continue on, that becomes malfeasance, misfeasance in office. It is not optional to maintain your position on a matter in a given issue. This mandates or should have mandated immediate withdrawal at the time that the matters were filed before the Supreme Court on the writ. The next most astounding claim of the Supreme Court at page 14, paragraph 4 of its ruling said that Judge Goodman, who was impeached, will face irreparable harm in the absence of the writ that was filed on her behalf before the Supreme Court. Goodman was impeached, folks, because she was doing irreparable harm to the public and to the judiciary. It is up to the legislature to make the ultimate determination on that. Moreover, there can be no irreparable harm if she gets a hearing and a trial in the Senate, which she is getting. The bottom line here is that if you've done wrong and found to have done wrong, it is absolutely and solely the prerogative and duty for the legislature to move that person from office. As the final reference to the opinion itself at page 14, paragraph 5, the Supreme Court says this matter does not present a non-justiciable political question. Here again, the Supreme Court is trying to pick and choose what part of the Constitution they are going to use. Moreover, the cases they cite are between executive and legislative, but here they have a conflict as this issue is between the Supreme Court, that is the judiciary, and the legislative branch. And as much as they have on multiple occasions, they've tried to pay homage to the legislature's absolute power of impeachment. They do not understand the definition of the word inviolable, which describes the absolute power with which the legislature is invested when it comes to impeachment matters. The court has intentionally attempted to modify the Constitution and without an amendment, and has violated the very amendment they depend upon, even going so far as to quote that portion of the Constitution that negates their conclusion. The court has stepped way outside of its bounds, and they cannot police themselves, and if they attempt to do so, they have committed an impeachable offense. And I will remind my listeners that these battles between the judiciary and the legislature have erupted in other states as well, wherein multiple justices of their Supreme Courts have been removed at one time, either by legislative action or by citizens' committees that arose because of judicial abuses. Now, it's up to the Senate to stand their ground to remind the Supreme Court that it cannot threaten that body of equal dignity. Given the outrageous decision that has been rendered, I would suggest to the Kentucky House and Senate that in the next legislative session that it take the necessary punitive actions against the Supreme Court. After all, it is the House that has the power of the purse. And if these elected judges cannot understand their limitations, then the legislature must act and protect its constitutional powers and its prerogatives. You know, I've been before the Supreme Court of Kentucky a number of times in my 45 years and under different judges. There are much brighter and smarter minds amongst the Kentucky bar than what sits on some of our courts. And the proof of that is in the hundreds, if not thousands, of appeals and reversals of judicial decisions. Just give that a thought. Let me warn the people of Kentucky that what the Kentucky Supreme Court has done is to declare itself imperial, and it is going to tell you and every other branch of government what it can and can't do because, as I said, ultimately anybody with $100 an attorney can declare anything to be of a constitutional nature, and then the Supreme Court can chime in and tell you what you can and can't do. By just that very declaration in the case at hand, the Kentucky Supreme Court has declared itself the ultimate ruler in Kentucky. That means that every citizen and business in Kentucky is in a precarious position. Moreover, any business outside of Kentucky thinking of coming to Kentucky to do business may want to give that a second thought, as the members sitting on our Supreme Court clearly cannot constrain themselves to the limited powers given them by the Constitution. As I read through the court's opinion and commented upon it to my listeners in part, in the whole, it was defensive, self-justifying, and immunizing itself to any judge in the state from any accountability. Moreover, the audacity for the Supreme Court to think that matters regarding a judge's conduct have to first be cleared to the Judicial Commission or the Disciplinary Committee that they control and to the exclusion of the legislature, that's absurd. This is like the fox guarding the henhouse, and the ruling and justification given in this opinion of the court is reprehensible. Let's take a look briefly at the most outrageous statement that one of the judges made. Judge Thompson, concurring with the majority opinion, wrote, "Threatening to file inappropriate impeachment proceedings and following through on them to disrupt a tribunal, influence the outcome of a case, and or to disparage a judge could result in KBA, that is the Kentucky Bar Association, discipline for any lawyers involved if attorneys take actions in which they are acting in bad faith." Additionally, such actions can constitute the crime of intimidating and participating in the legal process via the use of threat to influence or attempt to influence that person's vote, decision, or opinion. This constitutes a Class D felony. Folks, in my 45 years, I've never seen so many qualifiers because this judge knows he's on thin ice. In fact, this statement is so wretched, authoritarian, and it's downright Marxist in its tone, he deserves deafening condemnation. By Thompson's definition, anything could be considered threatening or disruptive. Appeals and arguments are just that. Does that make Judge Nichols' dissenting opinion disruptive? Thompson, in his opinion and his language he has used, is almost baratrus and metaphorically akin to barratry in his threatening tone to legislators who are attorneys. I would suggest such a tone is deemed to be for the purpose of silencing critics, designed to prevent public participation, or in this instance, the legislature. As a practitioner of law, as I said, for 45 years, I have never seen such threats, bullying, intimidating language used in any opinion from the Supreme Court. It is very unprofessional and sophomoric. I have never seen a Supreme Court threaten criminal prosecution against all the members of a legislative body before, and clearly they are trying to block the implementation of justice by using chilling language and keeping the legislator from using their sole and constitutional right of impeachment. It is this type of defensive CYA and injudicious bloviating that lands matters such as this before the federal courts, when state courts impinge upon basically like an attorney's free speech rights, or even the legislature. Moreover, when an attorney points out the errors of a judge on appeal, is Thompson threatening all attorneys and going to shut down the appellate process? If so, maybe he may have just put himself and the Supreme Court out of business. Thompson's reasoning is beyond the pale and suggests that even appeals can be considered a threat and subject an attorney's license to revocation. Moreover, threatening the legislative members to Class D felonies is removal language, folks. That's impeachable. Let's look again at what Section 109 of the Kentucky Constitution says about impeachment. Quote, "The impeachment powers of the General Assembly shall remain inviolate." End quote. That means absolute. And Section 66 says the House of Representatives shall have the sole power of impeachment. There are no qualifiers there, yet Judge Thompson tries to rewrite the Constitution and add language. He clearly does not know the definition of inviolate or sole power. How much clearer can it get? In my opinion, and reading of the Supreme Court's decision, it seems driven by politics and an attempt to usurp legislative powers, and I think the legislature sees that as well. Moreover, they try to define a misdemeanor which is not in the Constitution and therefore impinge upon the legislature again. That is the province of the legislature. So what are attorneys to think about Judge Thompson's bombastic language when they disagree with a judge, or when attorneys file appeals or even impeachment proceedings, which every citizen has a right to do? The Supreme Court's decision has a tone as if they are miffed by the fact that they just might have to be accountable. They exclude the possibility that a judge or any public official may have acted in such an egregious way that the impeachment remedy is the considered and chosen path in which to proceed. It truly appears as if Judge Thompson wants no accountability and seems thin-skinned when questioned. It's as if he's saying, and others are saying, well, how dare you question a judge in his language? You cannot limit anyone's right to seek redress before the legislature for fear that it may be classified or self-servingly interpreted as interfering with a pending case or to obstruct justice. Even the Bible is quite clear that we should not judge ourselves by ourselves, and that's exactly what the Kentucky Supreme Court is trying to do. Judge Thompson's threat is a direct attack on free speech as well as opinions that differ from his. He did what was a chilling and improper attack upon not only free speech, but the right to hold the courts accountable. How many errors, appeals, and reversals is a judge allowed before it becomes actionable and removal is required? I think this threat by Thompson is actionable by the legislature and may in and of itself be grounds for impeachment. Remember, it is the legislature who can set the parameters for the definition of a misdemeanor, not the courts. Justice Nickel echoed that sentiment with the opinion in his dissent. The court has overstepped its authority. Judge Nickel is the one sane justice on the Kentucky Supreme Court in his dissent, saying, "In my view, the majority's extraordinary and unprecedented use of this court's supervisory writ power to intrude upon the legislature's authority over impeachment erroneously oversteps the judiciary's role in Kentucky's tripartite government." And Judge Nichols further defines the term misdemeanor correctly, stating, "Misdemeanor in office as ground for impeachment has a much broader coverage than the common law misdemeanor is usually defined and applied in criminal procedure. As applied to impeachment, misdemeanor in office may include any act involving moral turpitude, which is contrary to justice, honesty, principles, or good morals. If performed by virtue of authority of office, misdemeanor in office is synonymous with misconduct in office and is broad enough to embrace any willful malfeasance, misfeasance, or nonfeasance in office. It may not necessarily imply corruption or criminal intent." Our U.S. Supreme Court has already declared that it cannot impinge upon Congress's authority over the impeachment issues. In responding to Judge Nichols' argument, Judge Thompson said, quote, "Respectfully," which I doubt, "we are not controlled by the U.S. Supreme Court interpretation of the impeachment power contained in Article 2, Section 4 of the U.S. Constitution," end quote. My response to that is, how Confederate of you, Judge Thompson. In a contemptuous statement by Judge Thompson in relation to how the U.S. Supreme Court addresses the impeachment issue, Thompson said, quote, "Our system is our own, and our judgment is our own, interpreting our Constitution." Wow, that's an end of that quote. Wow, I've never seen displayed or heard such dangerous and tyrannical bravado from our Kentucky Supreme Court. This is very injudicious and dangerous language. Let me remind Judge Thompson that he has been on the court a short time. He is there because he won an election. Now, given his language in his opinion, will he attempt to use parts of his ruling to win re-election and prevent any criticism from any attorney by threatening license removal or criminal sanctions because it might or could have some remote relation to any pending litigation? The court cannot stomp over the other branches of government authority and not expect to have any accountability. I believe Thompson's vituperous language is an unhinged threat to every attorney in this state, and he has overstepped his bounds as Justice Nichols has opined. There is virtually no precedent in this country in the way this court has attempted to immunize itself from any accountability. Hopefully there are legislators that will protect their prerogatives and power so they don't become the lapdogs of what looks to be an authoritarian and tyrannical court intent on seizing permanent power from other branches of government. This is important for every citizen in Kentucky, as is their house, the legislature, where the people have the most power and the greatest voice. So what we have currently are rogue justices trying to seize power that belongs to the legislature and the executive. If the legislature wants to maintain and protect their constitutional powers from usurpation by the errant Supreme Court, then the question comes down to how many strong men and women do we really have in the Kentucky Senate and our Attorney General? Effectively, what the Supreme Court has done with this decision is rid itself of any accountability through the impeachment process. I will also remind everyone that the courts around this nation have become the most imperfect and error-ridden body in government today. And all one need do is look, as I've said before, the number of appeals and reversals of court decisions and even decisions by the Supreme Court, and that they themselves have had either overturned or reconsidered. It is outrageous, and the people's branch of government, being the legislature, must take punitive actions against the judiciary for their malfeasance and malpractice. They must get politics out of the courts, and particularly the Kentucky courts. And it's going to take brave and strong members of the legislature to do this. This decision must not stand, and I urge every citizen and every attorney in the state to make your voice known or lose it. And with that, I'm Jack Richardson. for Jack's Corner.